Section 38 of the Constitution. Your Lordships, Section 38 of the Constitution provides for the right to freedom of thought, conscience, and religion. The court has said and described the rights of conscience and freedom in the case of F.M.O and F.M.O, citation before you, my Lord, as a right of a person to choose the course of his or her life without unjustified interference. On public policy, in Edet and Shagun, citation 2008, 2 MWLR, part 1070, page 85, particularly at page 105. The court cautioned that public policy is traditionally described as an unruly horse, and a judge has neither qualification nor experience in such equestrian matters. Thus, to render a decision solely on public policy or public good is to play the law with uncertainty, and it is against public policy to produce uncertainty in the law. Furthermore, in the case of Osamoni and Osamoni, citation before you, my Lord, the court per Fatayi Williams, JSC, stated that consent is not only basic but fundamental to either a potentially polygamous union, such as a customary marriage, or a monogamous union, such as marriage under the Act. Therefore, Section 6 of the Criminal Code offends this section in that the victim's right to freedom of thought and conscience is violated by way of consent. Your Lordships, on Section 42 of the Constitution, this section provides against discrimination of a person. Discrimination is regarded as a severe deprivation of human rights. Section 42 of the Constitution is further reinforced by Section 15, sub 2 of the 1999 Constitution, and it states, accordingly, national integration shall be actively encouraged, whilst discrimination on the grounds of place of origin, sex, religion, status, ethnic or religious association, or ties shall be prohibited. Your Lordships, a woman is not to be discriminated based on her status of marriage. In the case of Tolani against Kwara State Judicial Service Commission and others, citation before you, my lords, the court per Denton West, JCA, stated that, therefore, in my view, the appellant's marital status as enshrined in our domestic laws, with special reference to the 1999 Constitution of the Republic of Nigeria, and particularly since we are a nation amongst the Committee of Nations, I am of the view that our marital status rights as protected by international human rights domicile laws as applicable to this country ought to be reflected in the appeal. Otherwise, the appellants may still be deprived of fundamental justice. Thus, the exemption clause in Section 6 of the Criminal Code violates the status of a married woman. Your Lordships, conjugal right to have sex between spouses is not exclusive. Rather, it is to be consented to by both spouses. Again, as there is a right, there is a remedy to restore the conjugal rights. However, the use of force was never permitted in restoring these conjugal rights. Your Lordships, in conclusion, in consideration of the aforementioned cases and statutory provisions provided for in our brief, it is our submission that the marital rape exception contravenes, as contained in Section 6 of the Criminal Code, vis-a-vis the exception it makes for spousal rape, offends Section 38, so Section 33, 34, 38, and 42 of the 1999 Constitution, in the light of the one and the same principle and public policy consideration. We therefore pray this honorable court to uphold our arguments. May it please the court.
Your Lordship, I see the leave of court to call on my second co-counsel to canvass our second issue in our respondent's brief.
Maintaining my submission to the jurisdiction of this honorable court, I am F.M.O, counsel to the respondents. I will be canvassing arguments on the second issue of whether the Court of Appeal, in its majority decision, erred in law in finding that Section 36 subsection 8 and Section 36 subsection 12, either of them, did not operate as a bar to the prosecution, in line with the spirit and the letter of the law of the same provisions. Your Lordships, counsel to the respondents submit that the Court of Appeal did indeed hold the correct view that Sections 36 subsection 8 and Section 36 subsection 12 of the Constitution did not operate as a bar to the prosecution of the accused. It is quite intriguing, Your Lordships, that in this case, the spirit of the law is called into question. The spirit of the law, as defined by Black's Law Dictionary, 9th edition, 2009, is the intent of the law as opposed to its literal meaning. Now, the intent of the law in Section 36 subsection 8 and Section 36 subsection 12 of the Constitution was to prevent an innocent man from being targeted by a retrospective law, where this law sought to injure him of his rights or was unfair in the decision. In fact, Your Lordship, this provision was mainly popular and resourceful in the military regime when the military passed decrees which targeted individuals and was unfair in their holding. In Lacomi against AG Western States, citation for Your Lordships, the military decree sought to deprive the individual of his right to hold and acquire property, and the court held that this decree was specifically made against the person and could not be enforced retrospectively. The reason that this decision was made was because the decree would lead to manifest injustice. This principle has been held in recent cases, and in these cases, it mattered not that there was a previous law in existence. What mattered was the intent of the law to manifest justice, not injustice. I will proceed to provide a case where this has been held, and the case was contained in the brief of the appellant and was cited, albeit applied incorrectly. The case of Ibasa against States, citation Your Lordship, 1989, 9 Supreme Court cases 7. Yes, this case held that the innocent act of a person could not be transformed into a criminal act, but this was a ratio, a principle, to give the principle for the decision. What was held in this case was that a man who had committed murder, a new law which made the man, which allowed the court to convict the man, was applied in this case and then for other cases. When the counsel argued that the retrospective law could not be applied, the court held that that argument would not be valid, as in this case, the retrospective law did not cause manifest injustice. As a result, the court proceeded to apply the new law. First, where giving a judgment where it will lead to justice, the court should uphold it. The question is whether the law, the ultimate goal of the justice system, is to be lawful and legal or to be fair and just. Even when it is lawful and legal, we should follow the precedents laid down in achieving fairness and justice. The appellant was held, proceeding, to have violated sections 33 and 34 of the Constitution, and this is what caused the nullification of section 6 of the Criminal Code. Nothing else. It did not manifest from nowhere. It was from a violation of sections 33 and 34 of the Constitution. Therefore, one cannot hold that he innocently acted. This act had contents of malice in it, so he did not innocently act. And the principle behind the holding of prospective law cannot apply as the act was not innocent. Furthermore, Your Lordships, the appellant having violated provisions of the Constitution, sections 6 of the Criminal Code never existed. This is because section 1 subsection 3 of the Constitution holds that a law will be inconsistent to the extent where a law will be void to the extent where it is inconsistent with the Constitution. Now, no one needs to apply this, and the court does not need to state it. Where someone has inconsistent with the Constitution, it is automatically void. This was held in NPDC and NLNG, citation for your lordships, where the court affirmed that it does not matter whether a court has pronounced a law inconsistent with the Constitution, as it is automatically repealed where it is inconsistent. Therefore, in this case, the court is only reflecting the true provision of the law in upholding fairness and justice, in declaring that Section 6 of the Criminal Code was void and untrue. And as a result, we therefore submit that Section 36 of Section 8 and Section 36 of Section 12 cannot operate as a bar supporting a law which never existed. Hence, our prayer to this honorable court is that in order to fully achieve justice and give effect to the provisions of the law, our argument is upheld, the decision of the Court of Appeal is upheld, and our prayers contained in paragraph 6.0 of our briefs are upheld, as it pleases the court.
Okay, do you have the criminal code there?
Yes, Your Lordship.
Once more, I want you to read Section 6.
Section 6 of the Criminal Code, carnal knowledge. When the term carnal knowledge or the term carnal connection is used in defining an offense, it is implied that the offense, so far as regards that element of it, is complete upon penetration. Unlawful carnal knowledge means carnal connection which takes place otherwise than between husband and wife.
So, what you are saying is that the whole Section 6 is null and void, ab initio.
Yes, it was declared by the Court of Appeal.
In this matter.
Yes, Your Lordship.
Your Lordships, I remain K.L. Uzo, and I will be canvassing on the merits of our third issue on whether the Court of Appeal erred in law in finding that F.M.O did not operate in public law and therefore inapplicable in the instant case, and also whether the same principles of F.M.O, if found to be applicable in this case, does not serve as a bar against the AG's arguments against the constitutionality of Section 6 and to the prosecution of the accused. Your Lordship, before I delve into this issue, I will be explaining the concept of estoppel. Your Lordship, estoppel is a rule which bars a party in a suit from asserting or denying a particular fact. This rule was further defined in Section 169 of the Evidence Act 2023, which provides that when one person has either by virtue of an existing judgment, deed, or agreement, or by this declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and act upon such belief, neither he nor his representative in interest shall be allowed in any proceedings between himself and such persons or such persons' representative in interest to deny the truth of that thing. Your Lordships, flowing from this provision, it can be inferred that there are three constituents which must be fulfilled before a person can plead estoppel before the courts. One, there must have been a representation by virtue of word, act, or omission. Two, that the representation must have been relied upon. And three, that the person who has made this representation has suffered damage. Your Lordships, while there is an unavailability of cases as regarding the relationship between estoppel and public law, there is, however, an established principle of law that a person cannot be stopped from fulfilling his statutory duties. This has received judicial backing, Your Lordships, in the case of Oloyede and others against Roberts and another, citations before you, my Lord, where the court held that estoppel cannot diminish or enlarge the operation of a written law. The case further stated that F.M.O cannot prevail against a law or statute. Furthermore, Your Lordship, the court in the case of Uti and others against Inaugural and others, citations before you, my Lord, stated that it is the duty of the court to give the effect to the Constitution, and the parties cannot, by consent or acquiescence or failure to object, nullify the effect of the provisions of the Constitution. Your Lordship, it is important to note that the office of the Attorney General is not established by a mere statute. However, it is established by the highest law of the land, the 1999 Constitution. Section 195, sub 1 of the 1999 Constitution provides that there shall be an Attorney General of the state, who shall be the chief law officer of that state and the Commissioner for Justice of the government of the state. Furthermore, Your Lordship, the powers of the Attorney General are laid out in Section 211, sub 1 of the 1999 Constitution, which the Attorney General having the power to institute and undertake criminal proceedings, to take over and continue proceedings which may have been instituted by any authority, and to discontinue legal proceedings at any stage before the judgment is delivered. Your Lordships, based on this fact that the Attorney General obtains his powers from the Constitution, which is the supreme law binding on all persons and laws, as stated in Section 1, sub 1 of the 1999 Constitution, it can therefore be inferred that any attempt to limit or restrict the powers of the Attorney General without a constitutional amendment is engaging in a voyage of illegality. Your Lordships, it is for this reason that the courts have held, in the case of Newton and others against Longpong and others, citations before you, my Lord, that the rule of F.M.O cannot be used to sustain illegality. Your Lordship, it is therefore for this reason that the courts are critical, if not reluctant, to applying the rule of F.M.O on the constitutional powers of the Attorney General. As exemplified in the case of Omenyora and others against the states, citations before you, my Lord, the court held that in the exercise of the powers of the Attorney General to initiate, take over, or discontinue criminal prosecution in the courts, the Attorney General are seen as masters to themselves, such that nothing and nobody can restrain them from taking any step towards criminal prosecution in the courts. Your Lordships, applying the principles of law to the issue at hand, the respondents in the earlier case had made a representation in the course of entering a nolle prosequi as to the validity of Section 6 of the Criminal Code. And the appellant is praying this honorable court that this representation be binding on him as regards the prosecution of the appellant. However, Your Lordship, in doing so, it will restrict the Attorney General in the prosecution of the accused now appellant. And since F.M.O cannot be used to limit a constitutional function, the rule of F.M.O can therefore not apply. In conclusion, Your Lordships, it is therefore our humble submission that the rule of F.M.O will not apply to the office of the Attorney General and in extension to public law, because such rule will limit the public officers in the discharge of their statutory duties and functions. We therefore pray this honorable court to rule in our favor on this issue and grant the prayers as stated in paragraph 6.0 of the respondent's brief. May it please the court.
Thank you. Can you try to enlighten us
Okay, Your Lordship.
The message.
Okay. Your Lordship, 438. Let me, with your permission, right?
Yes,
Okay. Applying the principles of law to the issue at hand, the respondent.
The issue before the court.
Before the court, sorry.
Don't read what is in your mind.
Yes, Your Lordship. The respondent made a representation in another procedure as to the validity of Section 6 of the Criminal Code, which the appellant is pleading the court to bind him against making a contrary representation. However, the Attorney General will not be allowed to rely on a contrary statement as a basis for instituting an action. Therefore, the rule of estoppel would restrict the performance of his constitutional function, which is prohibited not only by the Constitution, but also by judicial authorities. Okay, Your Lordships, like how I explained before, the appellants are relying on the statements made by the Attorney General in the loaded procedure to say
in a matter,
a matter not before this court.
Yes.
Praying this court to allow that representation which has been made in that sense to bind the Attorney General in this suit. In other words,
to stop him from
making such
doing
representation.
something contrary to
Yes.
what he did.
And that representation is the basis of instituting this action in the first place, from the High Court to the Supreme Court. So, Your Lordships, based on that, this would therefore be accepted as a bar to the prosecution of the accused. It's therefore limiting the powers of the Attorney General if you apply the doctrine of the rule of estoppel in the prosecution of the accused, which the prosecution has the power to do by virtue of the Constitution. Therefore, the rule of estoppel cannot apply. If, however, there should be a limit to the powers of the Attorney General, the proper thing to do is to apply for a constitutional amendment where such powers and limits would be stated down in the Constitution.
We have understood your argument, but that particular paragraph doesn't appear to be elegant as to pass the message.
Okay.
That's why I pointed out.
Okay, Your Lordship. Thank you, Your Lordship. Make this the court.
Anyị obere ka ọ dị ndụ ma nkwa zụpụta ụmụ ya bụrụ ihe
eze ndị ara nọ na field eche anyị kemgbe Zubi Mike